The law in British Columbia provides that children and spouses of a person who leaves a will can challenge that will if they're either disinherited, in other words, they're not left anything in the will, or what they're left is not adequate. And so the law provides that a court can substitute provisions in the will for a distribution of assets that is adequate, just, and equitable in the circumstances. Now, and the circumstances will depend upon the means and needs of the parties, what assets they already have, and also the size of the estate and what other beneficiaries receive under the will. And there are a few things to keep in mind in situations like this. The first is that only children and spouses can apply to vary a will. And the children must be either biological children or adopted children. And stepchildren, regardless of how close they were with the willmaker and how long they were in a relationship with the willmaker, have no standing to vary a will, unfortunately. Spouses can be common law spouses or married spouses. And in the situation of common law spouses, they must have lived with the willmaker for at least 2 years and not have separated from the willmaker prior to the willmaker's death. And that's the same with married spouses. Provided they're married, legally married, and they haven't separated from the willmaker prior to the willmaker's death, then they too can apply to vary the will.